Hello everyone, this video is about Arbitration and Conciliation Act 1996. This is mainly relevant for CA final students who are studying Set C in self-paced online modules, and other law students can also see this video to know about Arbitration Act. And if you want to learn about Arbitration Act, stay with us and you will be learning a lot by the end of this video. So, Arbitration and Conciliation Act 1996. First we are going to see about fundamentals of arbitration. Now, you will all have a question. What is arbitration? Generally, if we have a problem, where we will go? We have a dispute and we will go to court and we will file a case. But what is the disadvantage? What is the problem in going to court? If you go to court, it will take a lot of time. 6 to 7 years will take to complete the case, and it will be expensive. Lawyers are very expensive. And then we need a quick solution. So court is not proper for us. So we have an alternative method. Primarily we go through court, but when we want to have a quicker solution, there is an alternative. This is the topic for today, alternative dispute resolution. Under alternative dispute resolution, there are various methods for solving quickly the cases. Mediation, arbitration, conciliation, negotiation. Now, under these four things, we are going to see arbitration today. Now, this is called arbitration. Now, let us see with the help of an example, what is arbitration. Okay, let us look at the example. For example, there are two friends, Ram and Krishna. They together wanted to start a cafe business. They both are the partners. They are doing it as a partnership organization. This is the cafe. They are the partners. Now they have started the business. Now, after some time, they get a disagreement relating to profit sharing. Now, for example, 100 rupees is coming as a revenue, and after reducing the expenses, you have 70 rupees. Now, in which ratio they should divide it between them? Either they should divide it in 1:1, or one person should have more. Should they divide it in 60-40? Like that, they are getting a lot of problem. Now, for solving this problem, they are exploring the options. In what ways we can solve this dispute? Now, they have two options in front of them. The first one is court, and the second one is arbitration. What is the problem in going to court? In court, it is a very slow process. It will take years to solve the dispute, and it is very costly. We have to hire lawyers and we have to pay them. It is costly, and it is a public process. The judgment will be uploaded on the court's website and anyone can view them, so it will not be confidential, and the thing can be viewed by anyone. Now, in arbitration, there are advantages for this. It is a very quick process. We are going to appoint arbitrator. He will decide the case quickly. It will not take years to complete the case, and it is cheaper. Instead of paying two lawyers separately, they can appoint an arbitrator and pay a fees to the arbitrator alone. It will be cheaper and it will be private. Only the three persons will know about this problem. The party 1, party 2 and the arbitrator. No outsider can learn about this problem. Now, these are the advantages of arbitration, and this is the disadvantage of court. Now you can know which side is advantageous and you can select accordingly. Now, after selecting arbitration, both of them, they have to appoint an arbitrator. Before that, they have to agree to submit the issue to arbitration. For that, they have to prepare a document, and then in writing, they have to write that we are agreeing to solve this dispute through arbitration, and both of them should sign the agreement. This is the arbitration agreement. Arbitration agreement can only be in writing. So, this is an arbitration agreement. Now, they are appointing an arbitrator, and the arbitrator will hear both sides without partiality. He should be independent and impartial, and he will make a decision. And after the decision is binding on both the parties. After the arbitrator has taken a decision, the parties cannot go back and say, I will not follow this decision. The decision is binding, meaning that both the parties should compulsorily follow whatever the decision is arbitrator is taking. So, this is a binding decision. This is about arbitration. Now, we have learned some key terms relating to arbitration. What is arbitration? Both the parties will appoint an arbitrator. He will make a decision. And what is the arbitration agreement? The agreement in which both of them written and signed, that is the arbitration agreement. And then, who is the arbitrator? Both of them will select an impartial person and an independent person to decide the case. He will be the arbitrator. And then, types of arbitration we are going to see. These are the key terms which you have to know before starting arbitration. And then there are certain limitations for arbitration. Only certain small matters can be dealt with arbitration. For example, a big case like murder cannot be dealt with arbitration, and you have to go to a court always. And this is the list of matters that can be referred to arbitration. Civil disputes, breach of contract. Two parties make a contract and any one party is breaching it, not following the contract. Now, in this case, the party who made a default, the defaulting party should pay damages to the suffering party. If you make a mistake, the other person will suffer. So this defaulting party should pay damages to the suffering party. This amount of damages we have to compute. For that we can appoint an arbitrator and it will be going through arbitration. And then right to office. If you have a right to go to work somewhere and the employer is denying you from doing the work, this is your right to office. If you have the appointment letter, you can go to the office and nobody can stop you. This is the right to office, and in that if you have any problems, you can go to arbitration. And then time barred claims. For example, you are getting a debt. You are getting a debt of rupees 1 lakh and you are not repaying it, and for a certain amount of period, the lender who gave you the money is also not asking you to return it, and after a certain period he cannot recover it from you according to the Limitation Act. Time barred, it is called as a time barred claim. For a claim, if you have to recover the amount, you have to go within a certain period of time. If you go beyond the certain period of time, you will not have any right to claim the amount. In such cases, you have to go to arbitration. It will be easy for you to negotiate and prepare a settlement between the lender and the borrower. These are the disputes that can be referred to arbitration. And there are certain disputes which cannot be referred to arbitration. As I said, murder, which is a criminal case, like that, criminal cases cannot be referred to arbitration. And then insolvency. Insolvency, we have a separate code called Insolvency and Bankruptcy Code that you cannot refer in arbitration. And then revenue matters, tax matters, GST, which you do not pay. There is a dispute between you and your government. This is a problem which you cannot solve by using arbitration. You have to go to court compulsorily. Now, these are the matters that cannot be referred to arbitration. This is the limitation of arbitration, but otherwise you can do arbitration for pretty much many matters. And the next thing we are going to see is the object of the Act. Now, this is the object of the Act. Arbitration and Conciliation Act 1996 was brought in with an objective to, it is an act to consolidate the law relating to domestic arbitration, international commercial arbitration, and enforcement of certain foreign arbitral awards. Now we have to know what is domestic arbitration, what is international arbitration, what is a foreign award, what is an arbitral award. First of all, we have to learn all these. So let us look at an example for learning this. First, we can see what is an arbitral award. In court, when you go to the court to solve a dispute, the court will make a decision and give it, and it will be called judgment. Like that, in arbitration, the arbitrator is equivalent to a judge and he will make a decision, and that decision is called as an arbitral award. Decision by the arbitrator is called as an arbitral award. In court we call it judgment, and in arbitration we call it arbitral award. This is the difference between judgment and arbitral award. Now you know what is an arbitral award, which is nothing but a decision by the arbitrator. Now next we have to see about domestic arbitration and international commercial arbitration. First, let us look at an example for international commercial arbitration. Now, for example, in the same cafe business, we can assume a different scenario. Instead of two persons from India running the partnership, we can have one person, Ram, who is an Indian citizen, who will be a partner, and the other partner is John, who is a US citizen, he is resident outside India. Now, if they have a problem between Ram and John, it will be referred to international commercial arbitration. Now, you can see the difference clearly between these two. When there are two Indian parties, this is a case of domestic arbitration. In case of two Indian parties, it is a domestic arbitration. But when one party is from India and the other party is from outside India, whether it be United States, whether it be United Kingdom, if the other party is from outside India, it is called as an international commercial arbitration. Okay, now at least one party should be from outside India. This is the basic thing. The definition we will be seeing later on in the chapter in detail. So, when two parties are Indian, it is a domestic arbitration. When at least one party is from outside India, it is an international commercial arbitration. That is the difference between these two. Now, let us learn about foreign award. Now, what is a foreign award? It is given under section 44. Before learning about foreign award, we need to know about New York Convention. New York Convention is an international convention which was brought internationally, and many countries are member states to the New York Convention. It is a convention for recognizing and enforcing foreign awards and foreign arbitration. Recognizing and enforcing foreign arbitration. Now, India is a member state to it. Now, this is the New York Convention and India is a member state. When we are going to learn about foreign award. Now, section 44 decides that foreign award is an award made in a place outside India. That is, it is seated outside India. What is a seat? That will be explained later. Now, the award is made in a place outside India, and for it to be a foreign award, the country where the award is made should be a member state of New York Convention. The award is made outside India, for example, United States. And the United States is a member state of the New York Convention. So, that award will be a foreign award. It should be made outside India, first condition. Second one, the country should be a member state. These are the two conditions for determining whether an award is a foreign award or not. Now, what is a seat? Award should be made in the place outside India. That is, it should be seated outside India. Now, what is a seat? The concept of seat in arbitration is given here. It is the legal place of arbitration. When writing the arbitration agreement, you have to decide what is the seat of arbitration. What will happen if you decide the seat? It will determine the law applicable to the arbitration. According to which law you have to conduct the arbitration. This will be decided by the seat. If you select the seat as India, now the arbitration will happen according to Indian Arbitration Act. Now, if the place of a seat of arbitration is decided as US, the arbitration will happen according to the United States law. This is the concept of seat of arbitration. It is a legal place of arbitration which will determine the law applicable to the arbitration, including the procedural aspects. Even the procedure will be according to the seat of the arbitration. Now, what is the seat of arbitration? How it will be related to domestic and international commercial arbitration? Domestic arbitration is how we are classifying it as domestic arbitration. Both are Indian parties. If at least one of the party is from outside India, then we call it as international commercial arbitration. While classifying the domestic arbitration, we see the nationality, whether they are Indian or outside India. This is what we see when we classify it as domestic arbitration. But when we have to see which law is applicable or which seat is there, for that we have to see the legal place. It will be mentioned in the arbitration agreement. A domestic arbitration which happens between two Indian parties may be Indian seated or may be foreign seated. That is, the legal place, it may be in India or the legal place may be foreign. And in the international commercial arbitration also, it is because at least one party is from outside India, it is an international arbitration. But the seat is, it can be India or it can be foreign. The legal place, they will be deciding in the arbitration agreement. So, this is the foreign award concept. Foreign award is an award made in a place outside India, that is seated outside India. This foreign award concept does not have any relation relating to international commercial arbitration or domestic arbitration. It is a seat-centric provision. Where the seat is, that is the important thing for the foreign award determination. If the seat is outside India and the member state and the outside India state is a member state of the New York Convention, then it is a foreign award. This is the simple definition for foreign award. Once again, I will recap what is the concept of seat of arbitration. Seat of arbitration is the legal place of arbitration which will determine the law applicable to the arbitration, according to which law the arbitration will be conducted. This will be based on the seat of arbitration. Domestic and international commercial will be decided based on the party. At least one party is outside India, it is an international arbitration. Both the parties are Indian, it is a domestic arbitration. Now, the seat, where the legal place is, where it is determined. It is determined in the arbitration agreement. If the legal place is India, it is an Indian seated domestic arbitration. If the legal place is outside India, it is a foreign seated domestic arbitration. And the arbitral award, decision of the arbitrator under a foreign seated arbitration will be a foreign award. And under international arbitration, if the legal place is in India, it is an Indian seated. If the legal place is in foreign, then it is a foreign award. Both domestic arbitration and international commercial arbitration can have a foreign award based on the seat which is given in the arbitration agreement. Now, this is the concept of seat. Now, let us get into the topic. For what we saw all this domestic arbitration, international arbitration, to understand the object of the Act. This Act contains the law relating to domestic arbitration, international arbitration, and foreign award enforcement. This is the object of the Act. Now, let us get into the topic in a detailed manner. Now, already we saw alternative dispute resolution process, negotiation, conciliation and arbitration. Now, there is something called as conciliation. It is also similar to arbitration, but the decision is not binding. You need not compulsorily follow the decision of the conciliator. In the arbitration, we have the judge known as arbitrator. In conciliation, the name of the judge is called as conciliator. And the decision is not binding. You need not compulsorily follow. You may or may not follow. Now, this Act has 4 parts. Arbitration Part 1, Enforcement of Foreign Awards Part 2, Conciliation Part 3 and Part 4 is Supplementary Provisions. Arbitration, this Part 1, it has a scope and Part 2 has a separate scope. This will be discussed later in the chapter. And along with 4 parts, we have 7 schedules in the Act. For what we have sections and schedules separately, the section gives about the procedures and all the things about the act, but some miscellaneous things are there which are not given in the act. For example, the fees which is payable to the arbitrator, it is given in a schedule. Like that, minor things which are not a part of the act but are necessary, it is given under schedule. You have to read the schedule separately. If you want to understand about the fees of the arbitrator, you have to read the respective schedule for that. This is the concept of schedule. And then this is the object of the act which we saw already, and then we can go into arbitration. Arbitration, as we saw earlier, is an agreement by which the parties agree to refer their matter to arbitration. Two parties, they will solve their issue by arbitration. This is called arbitration agreement. It will be in writing. The person appointed to resolve the dispute, who will be solving the dispute, he is called as arbitrator under arbitration. Now, arbitrator will make a decision. It is called as an arbitral award. And there can be more than one arbitrator also. In many complex cases, more than one arbitrator are required, and more than one arbitrator is called as an arbitral tribunal. There will be a panel of arbitrators for huge complex cases. The next topic is Arbitration Council of India. It is an independent body in India for promotion of alternative dispute resolution, conciliation, negotiation, arbitration. These are all the alternative dispute resolution things, and it will be promoted by Arbitration Council of India. These are the functions: framing policy for guiding arbitral institutions. There is something known as arbitral institutions, which we will study down. Here down it is given, and we will study after seeing ACI. Create uniform professional standards. It will give professional standards for arbitrators. Like for chartered accountants, we have ICAI, and for company secretaries, we have ICSI. Like that, for arbitrators, we have ACI. For arbitrators, this is the function of ACI. And then maintain a depository of arbitral awards. There are thousands of arbitration cases going on in the country. Now we have to maintain a place where all the arbitral awards are collected, and if anyone wants to see their award, they can go there and see the award. For that we need a depository, and it is maintained by ACI. It will contain all the awards which are made under Arbitration Act of India. The next thing is arbitral institution. For example, if it is a small problem, we can go to a lawyer and we can appoint him as an arbitrator and solve the issue. But for every case, we cannot go and search for arbitrators. So there will be some arbitral institutions which will have their own rules. There will be big law firms who have lawyers with years of experience in the industry and the relevant field. They will have that arbitrators ready-made, and we can go to them, we can tell the issue to them. They will appoint a arbitrator panel. There will be more than one arbitrator. They will be in the law firm. They will be appointed to solve our dispute. We need not go and search for individual arbitrators. Since it is a law firm, the persons will be very experienced, and it will be proper when we go to a arbitral institution. Examples are Indian Council of Arbitration, International Chamber for Commerce, Delhi International Arbitration Center. These are the arbitral institutions, and the work of ACI, one of the function of ACI is grading arbitral institution. There are several arbitral institutions. The ACI will grade 1 arbitral institution, grade 2 arbitral institution, like that there will be grades. Grading means it is based on the performance, how much cases they are solving, how it is working, what is the operation of the arbitral institution, like that they will see and they will grade. This will be helpful to select the arbitral institution for people with disputes. For big arbitration cases, they will select an arbitral institution with a very high grade. The grade will be given by ACI, as I said already. So this is the importance of grade in arbitral institutions. Now, arbitral institutions is over, and alternative dispute resolution, a short note is given. Methods of dispute solving that does not involve going to court. Other than going to court, you can use these alternative methods. Court is not in a position to bear the burden of entire judicial system. There are a lot of cases going, and they are pending because we do not have an efficient judicial system. It does not have a large number of judges. Only 21,000 judges are there approximately in India, and they cannot solve all the 3 crore cases. So we need an alternative dispute resolution mechanism like arbitration. And in arbitration, we have procedural flexibility. We can set the formalities according to our wish. There is no rigid formality like courts. And we saw about arbitration, object of the act, and the law is based on UNICITRAL, United Nations Commission on International Trade Laws. This is a model law upon which we have created our own Indian Act. There is a model law, and we have made modification to that and adapted it to our legal system as the Arbitration and Conciliation Act 1996. The main point is law is based on United Nations Commission on International Trade Laws. Now we can start the sections of the Arbitration and Conciliation Act. Section 1 is the short title, extent, and the commencement. This is not so important. You can read it from the book if you want. Now we are going to section 2, definitions. The section 2 contains definitions. Generally in all acts, section 2 is dedicated for definitions. The first definition is for arbitration. Arbitration means any arbitration, whether or not by a permanent arbitral institution. Whether you appoint an institution for arbitration, or you appoint an individual arbitrator, or you appoint a panel of arbitrators, if the arbitration happens according to this act, then it is an arbitration. Then arbitration agreement means an agreement referred to in section 7. The detailed definition of arbitration agreement is given in section 7. We will read it later in the chapter. There is a summary given here according to section 7. Arbitration agreement means an agreement by the parties to submit the disputes to the arbitration. All or certain disputes to the arbitration in respect of a legally defined relationship. One more important point is, where will the dispute be coming? There will be a legally defined relationship. For example, lessor-lessee relationship, seller-buyer relationship, owner-tenant relationship. These are all legally defined or contractually defined relationship. If there are problems or disputes between these parties, they can go to arbitration. Now, the next point is arbitral award. It is an inclusive definition. It includes an interim award. Generally, we saw that decision of arbitrator is the arbitral award. There can be many types of decisions. Final decision, once all the hearings and all the procedures are done, after all the procedures are done, the arbitrator will give a final award, which is the arbitral award. And it also includes an interim award. For example, still the case is not over, but for an interim award, we have to give a certain compensation or certain order which will be issued to facilitate the case. This is an interim award. This we will be studying in detail in section 9. What is an interim award? What is an interim order? This we will be seeing in section 9. Now, arbitral institution. Arbitral institution designated by the Supreme Court or High Court under the Act. This is also arbitral institution, like we saw International Chamber for Commerce. Like that, there are arbitral institutions. They will be designated by Supreme Court or High Court under the Act. This also we will be seeing later on, how the court will designate the arbitral institution to you. Now, next is arbitral tribunal, means a sole arbitrator or a panel of arbitrators. As we already saw, it may be a single person, or it may be individual persons working under arbitral institution. It may be a panel. We saw already. Now, court. The definition of court. Under domestic arbitration, the word court defines civil court. Under international commercial arbitration, the word court means high court. For domestic arbitration, in the law relating to domestic arbitration, wherever the word court is written in the law, it refers to a civil court. But in the case of an international commercial arbitration, the word court refers to high court. This is the point here. Domestic arbitration refers to civil court, but in case of international, it is a high court. Now, the section 11 refers to appointment of arbitrator. This we will study along with section 11 when it comes in detail. Now, this is the appeal structure under the Arbitration and Conciliation Act. First, for domestic arbitration, the arbitrator will give an order in the first step. After this, if you don't like the order, only certain orders are appealable, which is given under section 37. Every order of arbitrator you cannot go and appeal. Only certain orders, the list is given under section 37. Only certain orders you can go appeal against. The appealable orders can be appealed in district court in the first step for domestic arbitration. First, the arbitrator will give the decision. You don't like the decision, you can go to district court. And you can go to high court if the district court also does not satisfy you. And the high court will give a decision. If that also does not satisfy you, you can go to Supreme Court for domestic arbitration. But for international arbitration, directly after the arbitrator's decision, you can directly go to high court. And the high court will give a decision. If you do not like the decision, you can go to high court divisional bench. And if you do not like that decision also, then you can go to Supreme Court. In case of domestic arbitration, since it will be small case because both the parties are Indian, the first step is for district court. But in case of international arbitration, one party is from outside India. Generally, when a party is from outside India, the case will be a little bit bigger than domestic arbitration. So, the first appeal is directly going to high court. This is the logic behind the appeal structure. And then we have the definition for international commercial arbitration in detail. As we saw earlier, at least one party must be from outside India. That the party may be individual. There may be two individuals contracting, or one party might be body corporate, a party might be company, or the other party might be government. There may be a dispute between one party, person, and a government. So these are the different types of parties. In case of individual, at least one individual must be national or resident outside India. He should be a national, US national, or he should be resident outside India. For body corporate, it should be incorporated in outside India. for it to be an international commercial arbitration. In case of company, at least one party who is a company should have central management outside India. Central management, the main decisions for the company should be taken outside India. In case of government, the government should be of a foreign country. At least one of the party, where the party is a government, the government should be of a foreign country. For example, the government of United States, the government of England, like that, it should be of a foreign country. At least one of the party must be foreign. Foreign in case of individual is resident in outside India. Foreign in the case of body corporate is incorporated in outside India. In the company case, it is central management should be outside India. In case of government, it should be a foreign country government. This is the definition for international commercial arbitration in detail. The next point is legal representative. Now, what is a legal representative? Legal representative is one person who is incompetent or who cannot represent himself will be represented by another person. On behalf of the first person, another person will go and do the law things or legal formalities will be done by another person. Generally, it is done to appointed to represent the estate of the deceased. For example, one person dies. He cannot come and do the legal formalities as he is already died. So, you have to appoint another person to represent the estate of the died person. Now, we have an example for this. Let us see the example. This is the example for legal representative. For example, we can keep there is a family. Ram is the grandfather and Krishna is his son. Surya is his grandson. Now, Ram is a grandfather. He is already in an old age. Now, unfortunately, he dies. And when he dies, there are two types of situations which may happen. He may have written a will and he may not have written a will. When he writes a will, in the will it will be written that assets of Ram, the grandfather, will go to his son Krishna. If it is written like this, then Krishna will have all the assets which belonged to Ram during his lifetime. And in this case, the legal representative will be Krishna. If the will is not written, the court will appoint a legal representative. The assets of Ram will be taken over and it will be sold off, and if there are any debts or not, it will be seen, and the legal representative appointed by the court will pay off the debts due by Ram, and the remaining amount will be given to the legal hire. This is the work done by legal representative. In the case will not written, court will appoint the legal representative. The legal representative will consolidate the assets and pay off the debts if any. Now, this is the example for legal representative. Now, let's get into the definition for legal representative. This is the definition for legal representative. Legal representatives are agents having legal status. Following are examples of legal representatives. Person who represents an estate of the deceased person. As we saw, the person appointed by the court to look after the assets of Ram, the grandfather. And person who voluntarily intermeddles. And person on whom estate of the deceased devolves on the death. On that example, after the death of Ram, the grandfather, he has written a will and the assets have gone to Krishna, his son. In this case, the Krishna will be the legal representative because the estate of the deceased, the assets of Ram, came to Krishna on the death of Ram. This is the legal representative concept. Now, we are going to see section 2, subsection 2, the scope of part 1. Part 1 we saw, right, arbitration. The scope of part 1 is defined under section 2, subsection 2. This part shall apply where the place of arbitration is in India. The concept of seat of arbitration we saw now. That is the relevant concept here. Where the seat of arbitration is in India, part 1 shall apply. Where the seat of arbitration is outside India, the part 1 will not apply. But there is an exception to this. Provided that, subject to an agreement to the contrary, provisions of Section 9 interim measures, Section 27 court assistance in taking evidence, Section 37(1)(a) applies even when the place of arbitration is outside India. Generally, all the sections in part 1 will apply only when the seat of arbitration is in India. But these are 3 special sections where the seat they will apply even to foreign seated arbitrations. Even if the seat is in a foreign country, the section 9, 27 and section 37(1)(a) will apply. Now, this is the scope of part 1. Generally, part 1 will apply to where the seat is in India. But there are 3 special sections which will apply even when the seat is in foreign. Seat in outside India. Section 9, 27 and 37(1)(a) will also apply even when the seat is outside India. This is the scope of part 1 given in section 2, subsection 2. Now, this was also told in the case law Bharat Aluminium and Company versus Kaiser Aluminium and Company. This is an important case law in the Arbitration Act. The Honorable Supreme Court laid down the landmark judgment that part 1 will also apply to foreign seated arbitration. Generally, domestic seated only arbitration which have seat in India. will have to follow part 1, or part 1 will apply only to arbitration with seat in India. But for foreign seated arbitration, these 3 sections will apply. This is given in the landmark judgment. Now, the next thing we are going to see is arbitration agreement. The detailed section for arbitration agreement, section 7. As I told, we are going to see the arbitration agreement conditions. Now, it is an agreement by parties to submit to arbitration. This is the third time we are seeing this sentence, and I hope all of you remember what I told. In the form of a clause or a separate agreement, the parties decide the arbitration, and the arbitration agreement can be in the form of a clause or a separate agreement for arbitration. You are putting a main contract, the purchase agreement or a rent agreement, whatever the main contract you put, it may be separate. But the arbitration agreement, there are two types of including the arbitration agreement in the main contract. Either you can put it in the main contract in a separate place in the main contract, or you can make a separate agreement for arbitration, and that agreement will contain full only about arbitration. These are the two types, in the form of a clause or a separate agreement. It shall be in writing. This is compulsory. If you make oral agreement, it will not amount to arbitration agreement. It should be in writing. There should be a document. It should be written, and both of the parties should be signing the document. Only then it will constitute a valid arbitration agreement. Otherwise, it will be invalid. What and all will be considered in writing? It is a document signed by parties. It will come under writing. Exchange of communication through electronic means. For example, if you order a product from a cake shop or something like that through WhatsApp, and in WhatsApp the reply message comes from the shop owner that all the disputes will be solved using arbitration, and this person will be the arbitrator, and all the things are given. This is a message which was received by you through WhatsApp. You cannot say this is not in writing, because under writing, exchange of communication through electronic means, that is like WhatsApp messages, are also covered under writing. Exchange of claims of statement and defense alleged by one party and not denied by other. Then, for example, if you send a legal notice to the other party, and you are saying that there is arbitration clause or arbitration agreement, and the other party does not deny it. He is not saying that no, there is no arbitration, like that he is not saying. So when you say that there is arbitration and the other party does not deny it, then it is also covered under writing. Exchange of statement of claim and defense alleged by one party and not denied by other. One party is saying that arbitration is there, and the other party is not objecting it. Then this will also constitute writing. Then reference to document arbitration agreement if contract is in writing, and reference is such to make the arbitration clause a part of the contract. For example, you make a contract. There is a main contract for rent agreement. This is the main contract. In that main contract, there is a line giving that Annexure 6 is for arbitration. Annexure 6 is for arbitration. Now, Annexure 6 is the document, separate document, but you are giving reference of that in the main rent agreement. What is the intention for giving the reference? You are saying that we are going to solve the dispute by arbitration. For that, we need an arbitration agreement that is given in Annexure 6. Now, this is the clear intention behind referencing the Annexure 6 document arbitration agreement into the main contract of rent agreement. Now, when you give reference like this, it will also be a valid arbitration agreement. Now, this section is over, section 7. Now, let's recap once again what and all we have saw in the section. It is an agreement by parties to submit to arbitration. Okay. It may be in the form of a clause or a separate agreement. In the main contract, it may be a clause, or it may be a separate agreement also. It should be in writing. It may be like a document signed by parties, or like WhatsApp message, electronic means communication, and then exchange of claims of statement and defense. It may be in any of the three parts, and if it is in any three, if it is coming under any one of the three things, it will be considered as writing. And then reference to document arbitration agreement. You are remember, you are giving reference of an extra document which is separate, and the intention is to make it as a part of the contract. Now it is also an arbitration agreement, valid arbitration agreement. Now the next section is section 8, power to refer parties to arbitration where there is an arbitration agreement. For example, there are two parties, A and B. The A is the seller and B is the buyer. Now these two get a dispute. Now they have to solve it through arbitration. They already have an arbitration agreement. They have entered into arbitration agreement already, and that agreement is there. But buyer, what he does is he directly goes to court. He does not refer to arbitration. Now when he goes to court, the other party A should also come to court and explain his the arbitration agreement. If a matter is referred to court, arbitration agreement is already in existence, then the other party can raise an objection in the first statement of defense. When the court is asking A, what should you do, what is happening, they will ask the explanation statement from A. A, in his first statement of defense, the very first argument, the first thing that he tells in court should be that we have an arbitration agreement and we will solve through arbitration. if he tells like that, we are going to do through arbitration and there is an arbitration agreement, the court would be barred to take up that matter. Then that matter cannot go through court and we have to go through arbitration only. For this thing to happen, you have to tell that there is an arbitration agreement and the wish of and your wish to solve through arbitration in the very first statement of defense. The first argument should be there is an arbitration agreement. If this is happening, then the court cannot take up the matter and you can solve through arbitration. This is given under section 8. Now there are relevant case laws to this section which we will be seeing one by one. Hindustan Petroleum Corporation Limited versus Pink City Midway Petroleum. Explanation. The court is barred when a timely objection is made under section 8. As we saw earlier, the party should make in the very first argument that there is an arbitration agreement and we will solve through arbitration. This is given under this case law. And Mahesh Kumar versus Rajasthan State Road Corporation. Here in this case law, it is given that mere existence of the arbitral clause does not bar the court automatically. In the example also, there was an arbitration agreement, but just because there was an arbitration agreement, the court is not barred from taking that matter. The other party should make up in the very first argument that they have an arbitration agreement. Only if the argument is made, then the court will be barred from taking up that matter. If the other party does not say about the arbitration agreement, then the court can take up the matter without any problem. Objection must be raised not later than submission of first statement of defense. The very important point here, why I am stressing this so much is, this is the very important point in section 8. The very first argument, the first statement of defense should contain that there is an arbitration agreement and we are solving through arbitration. This is the first argument that should be there if you want to solve through arbitration. Now we saw that under section 8 subsection 1, you can in your very first argument you can tell that there is an arbitration agreement and go through arbitration. Now under section 8 subsection 2, when you have to make the very first argument of arbitration agreement, you need to have the proof that arbitration agreement was made. The proof is original arbitration agreement or the duly certified copy thereof. You should have the original agreement in hand. Only then you can go and say that there was an arbitration agreement. So this is the condition for saying the first argument. But if you do not have the original agreement and it is with the other party and the other party has gone to court, he will definitely not give you the original arbitration agreement. Now what you can say is that the party who does not have an original arbitration agreement, he can tell to the court that I do not have the agreement. The other party who has come and filed a case with you, he has the original agreement. And the court will order the other party to produce the arbitration agreement. And you need not produce the original agreement. The other party will produce it on behalf of you because that is the court order. So if you have to go through arbitration and there was an agreement, but you do not have the original copy of it, you can tell to the court that the other person has it, and you can get an order from the court to produce the document by the other party. This is given in 8 subsection 2. Now this is the end of section 8. Let us once again we can summarize what we saw in section 8. If a matter is referred to court, already there is an arbitration agreement. You have to give in the very first argument that we have an arbitration agreement. Then for giving that very first argument, you need the proof of arbitration agreement. That proof is the original arbitration agreement. If you do not have the original arbitration agreement, you can tell to court that the other party is having it and the court will order the other party to produce it. That's all about the section 8.